Welcome, colleagues. We're excited to have you join us here to talk about one of our most important documents, the Wealth Advisory Agreement. It's a document we utilize for every client relationship and arguably is in the top one or two documents that we have of importance. And outside of our Form ADV, this is a document that is essential. We wanted to share a presentation to go through some of the key provisions of the Wealth Advisory Agreement. We wanted to discuss some frequently asked questions around this document and just share some perspective on some of these sections. Joining me today are Jake Fector and Amanda Robinson, who also spent a lot of time in these documents, and I know are excited to share some information. So let's go ahead and dive right in. Obviously, starting with Section 1. So Section 1 should hopefully be fairly straightforward. It provides all of the details around the services that we are going to provide to clients. Of course, our suite of services are more comprehensive in nature than these paragraphs may articulate, but this is a general framework for the services that we're agreeing to provide to our clients. A couple key or important kind of paragraphs that we just wanted to highlight a little bit is one, the way in which we trade, right? It's outside of the fixed income, we have a directed brokerage relationship. So all of the mutual fund, ETF, equity trading, that's going to go all through the primary custodian for the client. And then of course on the fixed income side, we are taking on brokerage discretion, as you're aware, with our fixed income desk and going out and selecting various broker dealers to execute those trades, which is a great benefit to our clients. But that's essentially in the second paragraph. The other thing that I wanted to point out specifically in this paragraph is a number of details around our wealth planning, wealth management services, and specifically sort of the fact that a lot of these, of course, are financial planning. And with the CFP Board of Standards, we've got a number of disclosures or comments in there around sort of the importance of those professional standards of conduct and what we need to do there, engage in there. And then lastly, I think just, some important elements, which we are not obviously acting as our client's attorney, and we're also obviously not acting as that client's certified public accounting firm, even though we do, of course, have professionals here who happen to be attorneys, and/or we have folks who have the professional designation of being a CPA, which is a fantastic one, but we are not holding ourselves out as providing public accounting services. So why don't we go ahead and talk a little bit about Section 2, confidentiality. And Jake, maybe you want to cover that one for us?
Sure. Thanks, Sal. So the agreement has a confidentiality provision, which states in ways to say the information and the data that we collect through our client relationship will be kept in strict confidence, except as required by law. So by way of background, we have to report to different federal securities exchanges by some type of examination or audit or some type of subpoena. We may have to require to produce certain records, but that would be really the only way in which we're going to share this type of confidential client data. Otherwise, it's going to be kept between the two parties of the agreement itself.
And of course, Jake, with that one, right, we would also share information upon the client's direction in order to provide continuing services to their account. So that could be examples being sharing with the client's attorney or sharing with the client's accountant or other kind of related advisors for purposes of servicing that client account.
That's a great point, Sal. And two other items I'd mention here for this section is that we do have a separate privacy policy that speaks to some of the confidentiality outlined in this provision at the end of this agreement, which we'll talk about, but just wanted to tee up some of the synchrony between those two pieces. And then also mention that when and if multiple parties do sign an agreement, so thinking about cases of where a husband and a wife may sign, it is assumed, and we have this written in the section here, that there will be no confidentiality between those parties. So that was an important provision we added a few years ago to sort of bolster our protections related to unfortunate cases where a client may be going through a divorce. It's important for us to look back to the agreement itself, and as fiduciaries think about who signed the agreement, who do we owe fiduciary duty to, and that's why we sort of added this multiple party provision when thinking about confidentiality. Anything else, Sal or Amanda, on confidentiality?
I don't think so, Jake, and certainly we're always available for those circumstances or situations where we have that instance of clients going through a divorce. As you know, we've developed a number of sort of disclosures that can go along with that when that situation starts to arise, and perhaps their interests may start to diverge, and some disclosures that can go along with those divorce situations.
Perfect. So with that, we'll go to item 3 for authority. And in essence, this section allows our advisors and allows Buckingham to act in the client's accounts. So it establishes and grants a limited power of attorney where we have trading authority on their accounts to place trades, to buy, to sell, and to really serve as their advisor. And again, in this section, we emphasize that we are authorized without prior consultation with the client to do so. That frees up our advisors and really our operations team to place these trades without having to get a hold of the client. One other thing I wanted to mention here, we've recently built out some language in regards to our FIEX accounts. So the held away solution we have here, we do cite that there will need to be a separate engagement and agreement letter. There's important terms through that system of FIEX that the client needs to be aware of. And we sort of point to and reference that separate engagement at the bottom of this section. But with authority here, it's the client granting Buckingham and their advisor the authority to act in their accounts. Next is a very important section with standard of care, item 4 here. And we preview it first and foremost with our ultimate act as a fiduciary to client. But Sal, what else would you outline in this section here as important for advisors to know?
So thanks, Jake. Certainly, as you noted, key element here being this concept of acknowledging within the wealth advisory agreement itself that we are a fiduciary, and that's important not just for the Investment Advisors Act purposes, but also for ERISA and or Internal Revenue Code purposes, particularly as we work through some items related to rollovers and the disclosures that you have to provide there, inclusive of acknowledging your fiduciary status. So that one's a key and important one. But there's a number of other important elements of this section, and they're principally or primarily around the importance of disclosure and the fact that there is risk involved with investing, and there is risk involved with dealing with other service providers, as well as disclosure around some of the things that we specifically are not engaged in, including paying bills on behalf of a client. And so all of those things are important for a client understanding as it relates to standards of care. And then, of course, the utmost important provision that a client may want to see, but is also important for regulatory purposes, which is certainly we are not asking as part of this contract for any client to waive any rights that they may have under state or federal securities laws. And that's commonly a sentence we like to point to when a client is raising a concern or an issue. We make sure to point out that nothing in the agreement's waiving any rights that they may have under those laws, but also back to the first sentence, which is we always like to point out when a client is raising an issue with the wealth advisory agreement. At the end of the day, we are stating clearly that we are a fiduciary to that client. So those are, I think, are important ones to point out, Jake, with as it relates to that one. And then we get to provision number 5, compensation. This one certainly is hopefully obvious, which is right. We've got to have a disclosure around the fees that we may that we've agreed with that client. These fees are important, obviously, for contractual purposes and regulatory purposes, but also for Sarbanes-Oxley purposes. You've got to have agreed upon contractual fees matched to what we actually do. And certainly that's important to ensure the accuracy of that information. And then there are a number of other important items within this paragraph, which is to provide information that there are other fees and expenses that are involved in investing, and particularly in mutual funds and exchange traded funds, as well as markups within fixed income products as well. So those are all inclusive there. And then, of course, our custodians have separate and distinct fees as well. And then the last thing that I think is good to point out here is within this section, there is an authorization from the client to deduct advisory fees directly from their client account. So that's an important regulatory item to provide as well. Moving on to item 6, retirement accounts. This particular paragraph has evolved over the years. Originally, this paragraph was looked very different than what it looks like today, but it was an added provision to address the DOL fiduciary rule, of which, as everyone knows now, was vacated in 2018. But even though that DOL fiduciary rule was vacated, there are still important provisions or sections that are contained in disclosures that are contained within this section. We worked with our outside ERISA counsel to make sure that this particular section was designed and customized to address what we do. And it's important to note that while we are referencing ERISA in this section, highly unlikely that you would ever use the wealth advisory agreement for an ERISA governed plan. We have separate contracts for ERISA governed plans. So certainly our retirement plan team has their own set of documents for participant directed plans. We also have an ERISA specific document for a pooled plan or defined benefit plan. So that it's important to note that those there are separate agreements for those types of plans. But in the event that a wealth advisor agreement's used for an ERISA government plan, we have some important provisions there. But then more importantly, for common purposes, we may have assets that are governed by the Internal Revenue Code. And of course, one notes that while the Internal Revenue Code, of course, governs IRAs and the like, there are mirror kind of prohibited transaction rules within the Internal Revenue Code that there are under ERISA. And so we have to ensure that we're not engaged in a prohibited transaction whenever we're dealing with any IRAs. So in summary, this provision contains a number of important disclosure items for IRAs or accounts governed by the Internal Revenue Code and any ERISA accounts, and is important to be contained within our contracts. And we're happy to talk about any of these in greater detail separate from this presentation. So I think that sums up the retirement accounts section. And on that note, why don't I pass it over to Amanda to talk through sort of our labeled item 7 disclosure paragraph.
Thanks, Sal. So, section 7, the disclosure section, is really where we have a formal acknowledgement of the receipt of the firm's disclosure documents, being the ADV, Form CRS, and the privacy notice. And it's also where we're going to walk through certain risk factors of investing and disclose that the advisor doesn't guarantee any level of performance. We also disclose here that BSW and our employees believe in the same investment methodology and thus may buy and sell the same securities as the client. I'm next going to be discussing client representations, section 8. So here we're going to detail that the client is able to execute and enter this agreement. They have the authority and capacity to do so. This section emphasizes the importance of the client informing their advisory team of any significant financial changes. BSW operates off of the established and known circumstances that we see and can control. If the client doesn't update us on changes, we will not be responsible for any actions as a result of any omission or inaccuracy of the information from client, nor are we responsible for independently verifying the information. So Section 8 also discusses margin borrowing, which obviously involves additional risk. So we have a separate engagement agreement for any client that wishes to uh, utilize margin borrowing in their accounts. Now I'm going to be discussing Section 9, which involves client conflicts and joint conflicts. And this was previously mentioned by Jake earlier. So if two parties have signed the wealth advisory agreement, we owe fiduciary duty to the joint client. In these cases, we're able to process authorization from either party for a joint account. And as Sal previously mentioned, it gets really complicated when clients are going through a divorce, and we have guidelines for advisors when that situation does arise. So please feel free to reach out to the compliance mailbox for that guidance. So Section 10 involves proxy voting. So the SEC had came out with a proxy voting rule a number of years ago, in which they said that it is a fiduciary duty of an advisor to vote proxies unless you have a provision that states otherwise, which here we say that BSW does not vote proxies for clients. It is the client's responsibility. So Section 11 deals with other legal actions. In it, we state that any legal proceedings, such as bankruptcies or class actions, are the obligation of the client, and our advisors cannot and will not provide any advice on these matters, reiterating the point that we're not going to be offering any legal advice. Which brings me to my next section, no legal or accounting advice. We serve in an advisory capacity and do not provide legal or accounting advice. Now, the new section that we have just implemented involves Section 13, tax services. In our new offering, we will provide tax preparation services in certain cases as outlined by a separate engagement letter. And with that, I'm going to send it back to Jake to discuss consent to electronic delivery.
Thanks, Amanda. What we're trying to accomplish here with item 14 is getting in front of the client to get their consent to communicate electronically, primarily via email, by our client portal, and making sure that, one, the client acknowledges that they have the ability to do so, and two, also says Buckingham has the ability to communicate client information through these means. So this is an important provision as we think about our client experience moving forward, pushing for a more digital and a more electronic means of communications with clients. This section is a big part of that. And this was, for those advisors who've been with us for a longer period of time, remember a repapering effort a few years ago. This was a big driver of that, to kind of push our client experience forward. Item 15 is next, and that's the termination provision. While we'd like to always work with our clients and have them be successful relationships, we know, as much as our advisors know, that a termination and ending client relationships is ultimately still part of things. And so we need to have a provision that speaks to that. Some of the main points here: either party may terminate this agreement upon 30 days notice. So 30 days is an important provision within this termination clause. So that can be triggered by either the advisor, Buckingham, and or the client. The client is still obligated to pay fees through that notice period, and we outline that here as well. And it's also important to note here that the advisor has no obligation to take action on the account upon word of that termination. And so while we want to be helpful to clients, oftentimes when the client has decided to leave, that they are transferring those assets to a contra advisor, we certainly want to assist with that, but any activity or any help beyond that is going to ultimately be the client's responsibility. Item 16, next, for death, disability, or incapacitation. We actually grabbed this from one of our transaction partners as we were reviewing their advisory agreements and transitioning those clients onto Buckingham's template, we really liked this section and decided to put it into to our core templates to help think about situations, the unfortunate situations of a client either being incapacitated or losing some type of mental capacity. Again, thinking through sort of the diminished capacity risk in which our advisors have been trained on before and our team focuses on here. And so what we think about in this section is the concept of a significant life event. I mentioned death, incapacity, or diminished capacity. And in this section, we allow for both termination by some type of executor or guardian, in fact, but also giving possible permission to the advisor to report certain events of what could be perceived to be financial exploitation to trusted contacts that we have on file. Again, this is why our team makes a big push to get those trusted contact forms in place. This section also gives us the ability to take other precautions on the client's account when and if we think there's some type of exploitation going on. Situations where we may be able to withhold a distribution or work with our custodians to just delay a transaction, get others involved to make sure what we're sending out is indeed legitimate. The next section here is the assignment provision. We've talked about some of the sections within this agreement that are federally mandated by the SEC and by the Advisors Act. This being one of them, that every agreement needs to have some type of assignment provision. And so what we talk about here in this section is that, again, required by law, both parties, or there needs to be some type of assignment provision where both parties have an agreement about how a contract might be assigned when and if ownership changes within this agreement. I'll use a practical example here. Again, those of you who have been with us for some time remember when Focus changed ownership structures a number of years ago, we technically had an assignment of these agreements. And needed to look to this provision to figure out, okay, do we have what's called negative consent, to where we can process this type of assignment via notice and just reaching out and providing notice and communication of that assignment? Or rather, do we require positive consent or actually have to get a written signature back from the client? And so a big push we made a few years ago, which you'll see in our templates moving forward, is this concept of having negative consent. Operationally, to move our business forward when and if changes happen with either Focus or Buckingham in terms of our ownership structure, we need that flexibility to be able to still properly provide notice to clients when and if assignment changes, or sorry, when and if control changes. But by having a negative consent just gives us the flexibility to act a lot more freely. Sal, anything else you'd add on assignment before we go to dispute resolution?
I don't think so, Jake, other than a fun trivia question that we will send whoever's first to answer this trivia question. We will send you a surprise gift. All right, you ready?
I like it.
Okay, good. Does the Investment Advisors Act mandate a registered investment advisor to have a contract with their clients? So that's the trivia question for today. And the person comes first to the compliance mailbox with the answer will receive a special gift in the mail. Thanks, Jake, for that info on assignment. So on to perhaps one of the provisions that gets a lot of attention, which is dispute resolution. We're fortunate in the sense that this is a provision that typically we don't have to address in a real world perspective, in the sense that we don't end up in many disputes, which is great, but certainly is a provision that I think clients are focused on particularly because we do have a arbitration clause. Arbitration these days is certainly getting a bad rap, but from the perspective of what we are attempting to do here is we're really looking to get clients to understand that what we're wanting to do is have certainty as to the forum for a dispute. We're not asking a client to waive any rights or give up any rights that they may have. And of course, our contract explicitly does say that a client doesn't waive any rights that they may have under state or federal securities laws. We just want to have some certainty as to the forum to solve any disputes, and that's principally what our arbitration provision is designed to do. I think important to note that um, while we are happy to always have a dialogue around this provision and possibly, depending on the facts and circumstances, get to a place of being able to amend this provision, this is a provision that we're adamant must stay in our wealth advisory agreements. And something else I do like to always point out about our arbitration provisions is if you read it, we're really looking to have circumstances and situations that we would negotiate with a client in the event of any dispute to get to a good and just and equitable resolution satisfactory to both parties, and or we would mediate something to try and prevent us going into a full-blown arbitration. But in the event that we can't settle that matter through negotiation or mediation, the American Arbitration Association is the forum in which we would look to settle any disputes, of which, of course, the AAA is an independent organization for dispute resolution. So there's no sort of direct vested interest of either party as it relates to that forum. So moving on to the next section, section 19, amendments. This is a provision, of course, that's a standard sort of contractual provision as it relates to amendments to this document. One of the things that is contained within here is that we've tried to build in some flexibility because we all know how hard it is to track a client down to sign a new contract. We have built in some flexibility as to the amendment to that document be a negative consent. That's the amendment provision. Why don't I pass it back over to Amanda for section 20.
Great. Thanks, Sal. So section 20 deals with joint community and separate property. And here we kind of describe that if we have two clients who sign one wealth advisory agreement, but only one person is on a named account, that individual will then have ownership and rights for that account. We're always going to go off of account titling at the custodian level to determine ownership and rights. So I'm now going to go on to section 21, which deals with the entire agreement, severability, governing law, and other items. So here we describe that laws are ever changing. Therefore, we have stipulated here that if something in the wealth advisory agreement becomes unenforceable or invalid, it doesn't make the entire agreement invalid. We also state that the governing law is going to be Missouri. And the reasoning behind this is that our corporate headquarters and where we have our established legal resources are all located in the St. Louis office. And with that, I'm going to send it back to Jake.
Thanks, Amanda. Item 22 for electronic signature agreement. Short and sweet, this section permits the client to sign the document electronically and to sign future documents electronically that we may transmit to the client is here. So I mentioned earlier that this again helps us push for a more digital client experience with 23 counterparts here. The wealth advisor agreement may come across in different types of forms. It may come across in a PDF, a Word document, a DocuSign envelope, through Agreement Express. All of these versions together, and what we're trying to portray in this section here, will be considered effective and original versions that are eventually signed by both parties. They just might come in different parts or different segments. We want to spend a little time just on Exhibit A to the fee schedule here. And talk about some items we get questions on here. So again, we list the fee schedule, and the one we have here is just our standard fee schedule to date of this recording. But do want to note that we have language that says fees are prorated with respect to new accounts that may be open during a quarter. We get questions about intra-quarter flows, whether we're able to bill on those. So this section is important to keep in mind. Sal mentioned earlier the amendment provision being important to have that negative consent. We can amend the fee schedule within 30-day notice to clients and leverage that negative consent amendment capability as well. We talk about refunds and proration of fees in this section as well. But again, here is where we may customize a fee schedule for a client, agree upon that, and talk about some of the terms of billing itself. And then we wrap up with just delivery of the privacy policy at the end of our agreement. There's a requirement to provide a privacy policy to clients. And so what we've historically done and will continue to do moving forward is just to append that to the back of our wealth advisory template. That this ensures that we are adhering to that requirement to provide a privacy policy to clients. So we can always point to, yes, the client has signed a wealth advisory agreement that includes the privacy policy as evidence to the fact that we've delivered that document. So I'm going to pause and go back to Sal and Amanda. Any other closing comments here as we think about the wealth advisory agreement, or things that you might want our advisors to be aware of?
I just had one last thing to add that I would say about the privacy notice. Within the privacy notice is also the link for the California Consumer Privacy Policy. So if your client is a resident of California, they would fall under the jurisdiction of the California Consumer Privacy Act. So we have a detailed privacy policy for just California residents as well.
Thanks for that, Amanda. Yeah, I think that the closing kind of comments I would make, Jake, would be one, we appreciate very much everyone's time to spend with us, to take a look, a deeper dive into our wealth advisor agreement. Of course, we're always happy to answer any questions outside of the context of this presentation. And then hopefully you got some perspective on the balance that we try to have with this document, which is we try to really keep it in a plain English, short format, but with experiences along the way and regulatory changes and legal changes, it's been updated and expanded as we go through the years. And so hopefully you also got the perspective that there is a lot of time, care, and effort put into this document, and there are really important provisions contained within the document. And we're always open to feedback or information that you may have that may be important to incorporate into future versions of the Wealth Advisor Agreement. So we really very much appreciate everyone's input on this that we've had.
Perfect. With that, we will call it a wrap. Please email the compliance team with any questions related to this agreement. Thanks.